Well, welcome everyone and good morning. My name is Michael Rosen and I'm an adjunct fellow here at AEI. And my focus is on technology, policy, and intellectual property. These are the issues that we're going to be touching on today with our keynote speaker and our panel. It gives me great pleasure to introduce our keynote speaker, someone who has recently been called electrifying, impressive, direct, and forceful, which are adjectives, if I may venture to say, that are not typically associated with the director of the Patent Office. But in this case, if I may editorialize a bit, these descriptions are entirely warranted, as PTO Director Andrei Iancu has, in his 4 short months at the helm at the office, shaken things up, challenged many of the traditional pieties of its practice, and vigorously advocated a fresh look at numerous key issues. We at AEI are honored to host him today and to share and hear some of his reflections on the burning IP questions of the moment. But first, a proper introduction. As the Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office, Director Iancu oversees more than 12,000 employees, an annual budget of over $3 billion, more than 600,000 patent applications, and more than 300,000 trademark applications every year. And worth noting, this past week, Director Iancu put his name to the 10 millionth patent ever issued in the history of the United States, which is a very significant landmark. The director also serves as the principal advisor to the Secretary of Commerce on domestic and international IP policy matters. And before joining the PTO, Director Iancu was a managing partner of IREL in Manila, where he practiced for 20 years in Los Angeles. He's also taught patent law at the University of California, Los Angeles, where he received his law degree as well as a Master of Science in Mechanical Engineering and a Bachelor of Science, and Bachelor of Science in Aerospace Engineering. And without any further ado, again, it gives me great pleasure to introduce the director.
Thank you, Michael, for that very, very kind introduction. It really is an honor to be here with all of you this morning. Quick shout out for my friend George Kelly, who introduced me to the great work of AEI a little while ago. Over 80 years now in existence, I believe, AEI and its scholars have advanced ideas rooted in a belief in democracy, free enterprise, American strength, and global leadership, and in doing so have influenced and shaped the way millions of Americans think about a myriad of foreign and domestic public policy issues. So on that note, I would really like to especially thank AEI, and in particular Michael and his team, for organizing and hosting today's event. So I will talk a little bit about what we're doing at the PTO nowadays in a little bit. I will also talk a bit about some interesting statistics and the impact IP and patents in particular have on the national economy. But before then, since Michael mentioned electrifying, I don't know where that came from, but let me talk a little bit about electricity. Over the course of 6 months in 1893, more than 27 million people from around the world came to Chicago when it hosted the world's Columbian Exposition, a display of mechanical and cultural innovations to celebrate the 400th anniversary of Christopher Columbus's crossing of the Atlantic in 1492. Actually, the exposition was in 1493, 1 year later than it should have been because of a presidential election. But spread over 600 acres, the fair was a paradise in many respects. Pristine streets, well-mannered crowds, and the most advanced sanitary and transportation systems available at the time. A swamp was transformed in what some people called a white city. Venetian canals, castles built around the canals, elaborate fountains. There was even cannon fire and the choir singing Handel's Hallelujah. And when, on May 1, 1893, President Grover Cleveland opened the Exposition, it was truly electrifying. The author of The Wizard of Oz said that event is what inspired his book. According to Eric Larson in The Devil in the White City, the Exposition was like getting a sudden vision of heaven. At the center of the Exposition was the Statue of the Republic, designed by acclaimed American sculptor Daniel Chester French. And at night, the grounds and surrounding neighborhoods were illuminated by giant searchlights, the largest ever made, and said to be visible from 60 miles away. And while large colored bulbs lit the 100-foot plumes of water that burst from the McMonnies fountain, all of the fair's walkways and neoclassical buildings glowed with lights, dazzling and delighting visitors who had never seen so many lights ignited in one place at one time. This awe-inspiring city of light was the work of George Westinghouse and his company, and backed by technology from inventor Nikola Tesla. Westinghouse beat out Edison and won the bid to illuminate the Exposition, and in doing so enabled the public to observe firsthand and for the first time the abilities of alternating current, AC power. But the world's Columbian Exposition was much more than simply the first all-electric fair in history. It also marked the end of what is called the War of the Currents, as the fair made clear that AC was the power of the future. Indeed, from that point on, more than 80% of all electrical devices ordered in the United States were for alternating current. The War of the Currents started with a patent that had been issued 13 years earlier. After analyzing no fewer than what he said were 6,000 vegetable growths, and ransacking, quote, the world for the most suitable filament material, close quote. Thomas Edison, on October 21, 1879, completed 14 months of diligent testing with incandescent electric light bulbs and finally came upon one that lasted about half a day, more than 13 hours. And soon he got a carbon filament bulb to last 40 hours. And then, on January 27, 1880, Edison was granted patent number 223-898 for his electric lamp, an invention he considered his crowning triumph. Edison's work was based on DC current. Westinghouse later started to compete with an AC-based system developed mostly by Tesla. The famous battle that ensued between the two visions, AC versus DC, is heavy with meaning for the patent system. Edison once famously said, "Genius is 1% inspiration and 99% perspiration." Well, the patent system promotes and protects both inspiration and the hard work and perspiration that follows. Economists have shown that markets without protections for inventions generally lead to underinvestment in invention and innovation. There are several reasons for this. First, without the rewards promised by the patent system, inventors are less likely to take the risk and invest the resources and efforts necessary to create new things. And if they do create new things, without the protections promised by the patent system, inventors are less likely to disclose their creations to the public. Edison was an experienced inventor and patent owner, and the patent system acted as a significant incentive for him to develop the light bulb and electricity system. Further, without the public disclosure of innovative new technology, competitors and the public would have less information on which to base their efforts to design around. Indeed, they would have less incentive to create something new themselves. Tesla and Westinghouse, for example, expended a great amount of time and resources to come up with something different to avoid Edison's earlier patents. And in the long run, This incentive worked to the public's great advantage. For as you know, patents come with a quid pro quo. There is a bargain between the patent owner and the public. In exchange for the exclusive right the patent owner receives, inventors must disclose the details of their inventions to the public. In other words, the inventor gets its exclusive right, while the public gets the details of how to make, use, and avoid the invention. There is therefore remarkable symbiosis between the patent owner and the public. As James Madison recognized in Federalist 43 with respect to patents, quote, "The public good fully coincides with the claims of individuals," close quote. The results of our patent system over time, so carefully crafted and so carefully balanced, have been remarkable. Economists and other scholars have documented a number of important contributions from patents and other forms of intellectual property to innovation and economic growth. Our chief economist at the USPTO and his team, along with our colleagues at the Economics and Statistics Administration at the Department of Commerce, recently updated their report on U.S. IP-intensive industries, and some of the aggregate findings include: in 2014, IP-intensive industries directly and indirectly supported 45.5 million jobs, nearly 1/3 of all U.S. employment. Between 2010 and 2014, the value added by IP-intensive industries increased substantially, both in total amount and as a share of GDP. IP-intensive industries accounted for $6.6 trillion in value added in 2014, which is up more than $1.5 trillion, or 30%, from the $5 trillion in 2010. Accordingly, the share of total U.S. GDP attributable to IP-intensive industries increased from 34.8% in 2010 to 38.2% in 2014, and those numbers keep rising. Also, private wage and salary workers in IP-intensive industries continue to earn significantly more than those in non-IP-intensive industries. In 2014, workers in IP-intensive industries earned an average weekly wage of $1,312, which is 46% higher than the $896 average weekly wage in non-IP-intensive industries in the private sector. Further, data from the U.S. Department of Commerce shows that licensing and other revenue derived from the use of intellectual property generated a positive trade surplus of more than $80 billion in 2016. Additionally, a paper by a former USPTO Edison scholar presents causal evidence that patents help startups create jobs, grow their sales, and reward their investors. The results suggest that patents act as a catalyst to growth by facilitating their access to capital. The paper also found that approval of a startup's first patent application increases its employment growth over the next 5 years by a remarkable 36 percentage points on average. And the effect on sales growth is even larger. And when combined with other studies by academic researchers and organizations such as WIPO, it's clear that protecting intellectual property is vital to maintaining the incentives for research and development, supporting our visionary inventors and driving our economic prosperity. Let me also highlight some of the microeconomic areas where patents play a critical role. First, patents facilitate company R&D investment and new product introductions by both original inventors and competitors. This was certainly illustrated in the War of the Currents story that I just mentioned. Important work by economists has shown that patent protection itself confers additional value on innovation. One study estimates that this patent protection premium motivates U.S. companies to invest 33% more in R&D than they would otherwise, In other words, if patent protection were to be eliminated. Another study highlights how patents offset the market uncertainty firms face when developing innovation. It finds that by alleviating market uncertainty, patent protection motivates firms to increase R&D investment by 20%. Further, several studies have shown that patent protection facilitates the diffusion of new technologies. For instance, economists have shown that patent protection has been instrumental in the introduction of new life-saving medications across global markets. Second, patents are critical to entrepreneurs and startup companies. Based on survey data from early-stage technology companies, a 2009 study out of the University of California at Berkeley found that entrepreneurs use patents to gain competitive advantage, securing financing and enhancing reputations. Third, patents facilitate technology transfer and licensing. Economists understand technology transfer activities and licensing transactions as taking place within, quote, markets for technology, close quote. These are markets where sellers of new knowledge and technologies negotiate with buyers of knowledge and technologies. This is of critical importance in order to facilitate the movement of knowledge through our economy. Research shows that patents facilitate the creation and propagation of markets for technology, and they do this in at least two ways. First, through the disclosure function. Patents help to resolve informational misunderstandings between sellers and buyers, thereby facilitating transactions that would not take place otherwise. Second, patent protection increases the likelihood of a successful transaction by protecting a potential buyer from future misappropriation. Recent studies have also indicated that the markets for patented technologies have surged, increasing threefold since the start of the century, with trades involving U.S. priority patents driving much of the growth. The benefits of a well-functioning patent system are unmistakable. But now, for that system to function as intended, the system must be first and foremost predictable and reliable. Among other things, and at the very minimum, folks need to know within a reasonable band of certainty what subject matter is and is not patentable. As many in this room know, I believe that recent court decisions have made it more difficult to determine what is patentable and what is not. All else equal, it is less likely that inventors and investors would devote the effort and resources needed to create new technology if they do not know with reasonable predictability what the field they are working in is available for a patent in the first place. For example, would Edison have scoured the earth and invested all that time and money to make the perfect light bulb if he did not know whether light bulbs would even qualify for a patent? Edison was an experienced and prolific, multi-talented inventor. Wouldn't he rather invest his energies and resources in something predictable? It is incumbent on government to clarify this area of law. The USPTO is doing what we can to clarify, of course, within our statutory authority and Supreme Court precedent. In support of this effort, the USPTO issued this past April a new guidance memo addressing Step 2 of the Alice-Mayo test regarding what's known as conventionality. In the memo, we specify to examiners how to support and document their determinations of what is conventional, among other directions. In the months to come, we will likely have further guidance on other issues pertaining to patentable subject matter. As we develop the guidance, there are a few parameters we want to keep in mind. So when it comes to patentable subject matter, first, in my view, the system should spell out more clearly what categories of possible inventions we collectively, as a nation, want to exclude. In other words, assume a discovery is entirely new, non-obvious, and well disclosed. Do we still want to exclude it from patenting? If it meets all the other statutory requirements for patent protection, do we still want to deny a patent? And if so, what are the categories of such inventions we want to exclude? We should be clear. Second, the laws, in my view, should be industry neutral. The Patent Office should not be in the business of picking winners and losers between different industries. After all, many modern industries reflect crossover between technologies. For example, artificial intelligence techniques might be used for genetic sequencing in a biotechnology application. New inventions could very well blur traditional lines. More importantly, who knows what's going to come out tomorrow? Who knows what new inventions will come about and where they would fit in a scheme that discriminates between different industries? And who knows where such new technologies would fit? So in the months ahead, we will have more to say on this subject, and I encourage all of you to participate. Then, once issued, the patent grant needs to predictably mean something to both patent holders and the public. Both the owner and the public need to be able to rely on that grant. With this in mind, our post-grant review process has been subject to a lot of attention lately, as most of you know. Some argue that it is unfair to patent owners. Others think it is the best tool we have to control for patent quality. I believe we need a carefully balanced approach. For example, the scope of an issued patent should not depend on the happenstance on which court or governmental agency interprets it. At least that is true, in my view, as far as the objective rules go. And so, in order to increase predictability and certainty, we have proposed that there should be one standard used to understand the scope of an issued claim in both an IPR and civil action in district court. Otherwise, it is that much more difficult to predict, to invest, and to invent around issued patents. So to that end, we have issued a notice of proposed rulemaking to change the claim construction standard in our post-grant trials at the PTAB. The comment period is open until July 9, and we welcome any comments you might have. We are also looking at other aspects of IPR proceedings, such as the institution decision, claim amendments, and other things. So regarding the institution decision, we may want to consider things like the impact of other court proceedings, whether other petitions have been filed on the same patent, and the efficiency of the patent system as a whole, including validity and enforcement issues, among other things. We should take a holistic approach to fully implement the intent of the AIA, which I believe was for AIA trials to be a true alternative to district court litigation, not a consistent multiple bite at the apple. We are also looking at improving the amendment process in IPR proceedings. In essence, I do not think the IPR or PGR process should be an all or nothing approach. So at the high level, when it comes to amendments, I believe that we should have a system that has some of the following characteristics. One, amendments should be within the 12-month statutory time frame to the extent possible. Amended claims should be addressed in the final written decision by the PTAB panel. And both sides in the IPR should be allowed to participate. In general, the overall goal is to increase predictability, transparency, and achieve a well-balanced process that is fair to all. Now, these are just some of the issues we are working on at the PTO, and there are quite a few other things that are keeping us busy on a day-in and day-out basis. But as we do this, it is important to step back every now and then and consider the bigger picture. 2 days ago, the PTO celebrated the issuance of Patent 10 million, with President Trump and others at the signing ceremony in the Oval Office. That was a remarkable event, As most of you know, George Washington signed the first patent. And then other presidents in the early days of the Republic signed patents. Adams, Jefferson, Madison, Monroe, and up to John Quincy Adams. Each one of them signed patents. After John Quincy Adams, though, the only other president to sign a patent was Gerald Ford in 1976 to mark the bicentennial. And then the only second president to do so is Donald Trump just earlier this week. This indicates the significance intellectual property has achieved in our country and in our economy. And this indicates the importance this administration places on intellectual property. 10 million patents is a truly remarkable accomplishment to this nation. It is a testament to American imagination and perseverance that has changed the world. It is an accomplishment that far exceeds the patent activity of any other country to date, and demonstrates that the U.S. patent and trademark system is not only the backbone of our economy, but it is also the core of innovation, invention, entrepreneurship, and human progress. It also demonstrates how U.S. inventors, businesses, and entrepreneurs alike rely on a strong intellectual property system to protect their business interests and create jobs that continue America's global economic and technological leadership. Protecting the intellectual property rights of our nation's creators, inventors, and entrepreneurs is something I am personally very passionate about and fully committed to as we lead the U.S. PTO. We have a remarkable patent system, born of our Constitution and steeped in our history. It is a crown jewel, a gold standard, and we have a unique opportunity to ensure it meets its full constitutional mandate to promote innovation and grow our economy. I look forward to working with you all in support of that great endeavor. Thank you again for the invitation to participate in this important discussion, and I hope you have a great rest of the meeting. Thank you, Michael.
Thank you very much, Mr. Director, for your wonderful, enlightening remarks. We'll now take a couple of questions. So just as a reminder, please identify yourself and any organization you represent. And also, please make sure your questions end with a question mark. So, sir, you had your hand up first. We have a microphone circulating, too.
Thank you. My name is Bert Ely. I'm a banking consultant here in the D.C. area. On a personal note, a great uncle of mine is a predecessor of yours as director of the PTO. My question relates to business method patents and business method inventions and the potential for a greater degree of patentability of business method inventions.
So your question is, what is the PTO's view on business method patents and increasing the patentability of business method patents? That is an important, lively discussion. It is a discussion that we need to have as a group and as a nation. Again, the question is, assuming that business methods or whatever other technologies we might come up with, if they are new, non-obvious, fully disclosed, well-claimed, are there reasons as a country that we still want to prevent a patent on them? And this is a complicated question, and it has broad policy implications. There is a question in my mind as what it means to be a business method. The term itself can have very fuzzy edges. So in the first place, we need to identify what we have in mind when we say business methods. So for example, are we talking about literally how to conduct transactions between two companies? For example, a method as in the Alice case, where we are talking about an escrow vehicle. Is that something that we as a nation want to patent, and is it something that was meant to be considered the useful arts? There are all sorts of other human interactions, and do we have those in mind as business methods? For example, what if somebody comes up with a new sports play? A great football coach comes up with a new play for football and applies for a patent. It's a human interaction. Assume it's brand new. Nobody thought about it before. Assume it's completely non-obvious, and it's well disclosed pursuant to 112. Is that something we want to grant a patent on? All sorts of other types of human interactions. So first we need to figure out what the categories are that we are talking about here, and then we need to have a national discussion as to whether we want protection on those types of things or not, and is it what the founders considered to be the useful arts when they included that phrase in the Constitution.
Thank you. Sir in the back? Oh.
Good morning. Timothy Lee, Center for Individual Freedom. First of all, thank you. Too often you get criticism when you're in a position that you are, criticism and controversy, but you're doing great work over there, and so we'd like to thank you for that.
Thank you.
Unfortunately, over the last administration, the U.S. fell from its traditional place as first in the world in patent protections and innovation to currently 16th. So again, thank you for your efforts on that in terms of claim construction, and obviously things like the Stronger Patent Act before Congress can help get us back to where we were. If you could give some thoughts on that, and also what else we can do to help advance your work in getting us back to that #1 position that we've traditionally held. Thank you.
Thank you for the question and for the comments. I appreciate the kind remarks. The U.S., depending on the survey one looks at, the U.S. Patent system has fallen in ranks. You may have been referring to the U.S. Chamber of Commerce study. I'm not certain. In that study, we have fallen to number 12 in the latest study. And that is a reason for concern for me and for the administration. In that particular study, there were two main reasons identified for that decrease in ranking. Number one was uncertainty surrounding patentable subject matter, and number two was the perceived high rates of invalidity at the PTAB during IPR. So we are looking at, as you've heard in my speech, and as I've been talking about quite a bit, we're looking at both of those issues. I think it is important to return a higher degree of predictability of our patent system, and reliability. In other words, once issued, there should be an element of quiet title to the patent grant. Now, I want to emphasize that I strongly believe that the U.S. IP system remains the gold standard in the world. This is the country that initiated from the very beginning the reliance on intellectual property, and everybody looks to us as to what it means to have a good patent system. And I believe we continue to lead the world. In that ranking, for example, we are only half a point behind the leaders. The leaders are very compressed at the very top. And I think even in that ranking, we can quickly get back to the top. In terms of what folks here can do, one thing I didn't speak about today, but I speak about quite often, is I think the country needs a new dialogue with respect to IP and intellectual property and the patent system. We need a dialogue that is focused on the goals, aspirations, and successes on our IP system, on the amazing brilliance of our inventors, the excitement of the act of innovation, the incredible benefits they all bring to the economy. And folks in this room, folks you work with, clients if you're in private practice, there are so many examples of such incredible work that is being done out there with technology and innovation and backed by our patent system. Those are the stories that need to be told, and they need to be amplified. There are always stories that can be told about the faults in the system. Every system, especially something this big as our IP system, every system has faults. We'll work to correct them. But that cannot lead the discussion. The discussion for a successful system must be about the successes of that system. And it is incumbent upon all of us to emphasize those.
Thank you. We'll take one more question, sir, in the back.
I'm an independent inventor. I'm not sure there is any other small inventor in this hall. The reason I decided to ask this question now because it follows your discussion about the present system. Sure, the U.S. Patent Office position has fallen down from number 1 to 12. And we have talked about external problems, but there is one problem that I would like to bring to your attention, which I tried to do sending you emails, and when I met you outside, you said, I don't know. I don't think those emails have even reached you. There has been deep-rooted, widespread corruption among examiners, their SPEs, and even at the PTAB. There was an article published in the front page of Washington Post, August 11, 2014. I don't know how many of you have access to that or remember that, but that article exposed all the wrongdoings the examiners were doing, and they were being covered up. Their wrongdoings were covered up by the top management. I have also sent you that article, sir, but I don't think it has reached you. This all was done with the previous administration. The reason I'm bringing it up, I'm suffering because of that corruption for the last 7 years. When I filed my first patent application in 2011, and it was illegally rejected, means the examiner totally ignored the patent laws, and he kept on rejecting my application. When I filed a complaint to the supervisor, he yelled at me, he wrote me a nasty email, and he said, we will examine your application after 2 to 3 years. And
Sir,
it has been 7 years.
I'm sorry, in the interest of time, could you just ask your question?
Okay, so
please?
my
We
question
need to
is,
keep moving.
so that
Thank
was
you.
my first application rejected, and after that I was blacklisted. Now I filed a second application, and when you came to the office, I sent you an email about complaint of that thing. And I was afraid the same thing happened, complaint never reached you, and my second application has been rejected the same way. So my question is, how can small inventors like us can actually reach to you and bring that thing to your attention, and justice should be done to them? Thank you.
Thank you for the question. So we get over 600,000 patent applications at the PTO every year. We issue over 300,000 patents or so every year. I am not familiar with your specific situation. All I can say is that I believe firmly that our patent examiners as a whole, we have a core of over 8,000 examiners. Our examiners as a whole are highly educated, very diligent public servants, working day in and day out under sometimes difficult circumstances, difficult sets of laws, difficult technology, to do the very best they can for the patent system. Obviously, there are always going to be, as I said before, some errors in the system, and when we uncover them, we work promptly to correct them. As a whole, though, this is an incredibly dedicated and highly qualified group of public servants. Thank you.
Thank you. I'm sorry, sir, we need to... Thank you, sir. We, in the interest of time, we need to move along to our panel, so I would like to thank you very much, Mr. Director, for your very insightful and incisive contributions, and we wish you continued good luck in bringing bold and thoughtful leadership to the office, and we again thank you for your time.
Thank you, Michael, and thank you, AI. Thank you, all of you, for being here.
Thank you so much. We really appreciate it. And we'd now like to invite our panelists to come to the stage and take your seats. It's now my great privilege to initiate a conversation with our distinguished panelists about a number of issues touched on by the director and some additional ones as well. and I'll just jump right in with introducing our panelists. All the way on my right, on the far end of the aisle here, is Mark Bourne, who's an intellectual property attorney with nearly 20 years of expertise in creating IP strategies, evaluating technology portfolios, and managing complex cases around the world. His keen eye and understanding of the need for realistic risk assessment in handling all matters around IP provides the Marconi Group with key insights into resolving conflicts between licensees and licensors. Mark previously clerked on the Federal Circuit Court of Appeals as well. Thank you for joining us, Mark. Great to have you here.
Thank you. I appreciate it.
We can hold our applause for the end after I finish introducing everyone. To Mark's left is Aaron Cooper, who serves as the Vice President of Global Policy at the Business Software Alliance, where he leads BSA's global policy team. Aaron previously served as Chief Counsel for Intellectual Property and Antitrust Law for Chairman Patrick Leahy of the Senate Judiciary Committee, where he was responsible for drafting, negotiating, and developing the legislative strategy for enactment of the Smith-Leahy America Invents Act. Mr. Cooper is a graduate of Princeton and Vanderbilt Law School, and he clerked on the Court of Appeals for the 11th Circuit. So welcome, Aaron. Thank you for being here. Next to Aaron is Mike Lemon, who's the Director of Federal Government Affairs and the Counsel for the Internet Association. He previously worked with Senator Mike Lee and on the Senate Judiciary Committee, where he focused on intellectual property, privacy, antitrust, and immigration. In 2006, after graduating from Brigham Young University with a music degree, Mike took 2 years off to serve as a missionary in Houston, Texas, working with the Spanish-speaking population there. And in 2010, Mike received his JD from BYU Law School. Welcome, Mike. Thank you. And last but certainly not least is Hans Sauer, who's the Deputy General Counsel and Vice President for Intellectual Property at the Biotechnology Innovation Organization, known as BIO, where he advises the organization on patent and other IP-related matters. Previously, Dr. Sauer was the Chief Patent Counsel for MGI Pharma, Inc., and Senior Patent Counsel for Guilford Pharmaceuticals, Inc. He holds an MS in Biology from the University of Ulm, a PhD in Neuroscience from the University of Lund in Sweden, and a JD from Georgetown University Law Center, where he also serves as adjunct professor. Welcome, Hans.
Thank you.
And now we can clap for everybody. Someone might have said, please clap. All right. We're going to jump right in with our questions and answers. And we've asked a few of the panelists to sort of speak to a number of these things, but we're going to start with you, Mike. And I'm going to ask you, what are the 3 most important changes that we should or should not make to the patent system?
Well, thanks, Michael. I think first off, the most important part of having a good, reliable patent system is patent quality. And so it's really important that we enable our patent examiners to have all the tools that they need to make sure that the patents that they're granting are of high quality. And I think that when you look at the sheer numbers, as the director pointed out, there are over 600,000 patents a year, or patent applications a year that they receive. They issue over 300,000 patents a year, and each examiner has less than 20 hours to examine each of those applications. And because the patent applicant doesn't have to provide any prior art searching or distinguishing, all of that falls to the patent examiner to do. And frankly, it's just not enough time to do that for most of the patent applications that they receive. And especially in patents in the software and internet sector, quality issues have come up more frequently than others. In fact, a patent in the internet sector is 9 times more likely to be litigated. And so we think that to work on that, we should increase the training and time that examiners are given to look at patents. We should continue to have management that focuses on quality over quantity, and we look for PTO to continue giving guidance on how best to move forward.
Great, thank you. Hans, same question for you.
Oh, 3 things.
3 things. You can also name 2 or 4 if you wish, but
good.
Let's try for 3.
So I would start by saying the first thing we should do, and this is where I really think the director deserves support, is we need a renewed and fresh dialogue over patents and the role they play for innovation, trade, prosperity, and other societal benefits in our country. Right? We do need, I think, a conversation that focuses on the benefits of the system, and because we've had a conversation about its faults for about the last decade, and maybe it's time to talk about something else for a change. I do think there is the prospect of having a productive dialogue in that space. The second thing we should do is we should work on PTAB reform. This is probably the issue I hear about most from BIOS members, from our member companies who experience the PTAB system overwhelmingly in the role of patentee. We should work on encouraging earlier challenges that use the PTAB system. That's what it was there for. Right? If it is a patent quality tool, it should be used early during the life of the patent and not late during the life of the patent, which seems overwhelmingly to be the case today. We should reassess the system in ways that provide more finality and avoid repetition, and to make it work better with district court, because we know that more than 80% of all patents that do get reviewed at the PTAB are in fact in district court litigation, are involved in commercial disputes. Finally, in the area of substantive patent law, what we really should be doing is we should be taking another look at patent-eligible subject matter under Section 101. The current state of the law is a problem not just for businesses, not just because it creates commercial uncertainty. It's not just a problem because it's a problem of trade and international relations if we deny patents on things that our trading partners and countries with which we compete allow patents on. That is an anomaly. It's also a problem, I think, for the orderly development of the law. In my view, the state of Section 1 jurisprudence has interfered with the development of the law and of jurisprudence in the areas where it's most needed. And what I mean by that, for example, is in the space of, let's say, disembodied, problematic patents on processes or methods that don't seem to be grounded in any particular technology. If the courts have a new tool to get rid of these cases and invalidate these patents under Section 101, that's going to hamper the development and the application of other doctrines of patent law that really perhaps should more fittingly be applied to these cases. Right? So in areas where it's most needed, Section 101, I think, has interfered with the development of other doctrines. And Section 101 itself, in my view, is not capable of orderly judicial development. This is not a doctrine that can grow, morph, and change over time. The only way the courts have been able to develop law in this area is put a little bit of a leash on it. But that's not substantive development of this area of the law. So that's what I would have to say. Patent quality often does come up. I agree we should never take our eyes off patent quality, but I do want to put in a plug for the quality of U.S. patents. Our companies do a lot of business internationally, and it's not our impression that U.S. patents are conspicuously of poorer quality than the patents that are granted in Europe or in Canada or in Japan or Korea or in other countries with whom we trade. That too, I think, as a matter of benchmarking, deserves some conversation.
Can I,
Makes sense.
would you mind if I pick up on...
Yeah, please jump in there, and then we'll get Mark. That's all right. No, please, go ahead.
I thought Hans's first point, I think, was a really important one about improving the dialogue. And I think it's important not just in the public dialogue, but also inter-industry dialogue. Because too often, I think we get bogged down in buzzwords that have long-standing connotations that make it seem like some companies love patents and other companies hate patents. And I think it's much more nuanced than that, and we can, by improving the dialogue amongst ourselves, I think we can agree on some principles, and from those principles help continue to improve the patent system. So just as an example, I think regardless of what industry you're in, and regardless of whether you think of yourself more as an inventor or an implementer, the importance of patent quality, if we take away conversations about specific sections of the code and whether how the examination should run, but think about do we want to be granting patents on certain technology, and do we all agree that the contours of the claim should be clear? So whether you're the inventor or the implementer, you know exactly what is being claimed. I think if we could start having conversations around those issues, it'd be a lot easier for us to have good conversations around specific issues in IPR and in 101 jurisprudence.
Great, thanks. Mark?
Yeah, I don't disagree with a lot of what's been said. Just to place some of this in context, I'd like to give a little bit of background of sort of where we sit in the ecosystem. At Marconi Group, we really sit sort of in the middle. We try to develop licensing platforms for some of the most advanced technologies in the world, and then we try to match those with licensees who need a license to that sort of technology, that want certainty in the marketplace, that want to be able to sell without being subjected to, the myriad of lawsuits they didn't anticipate. And so we try to sort of work in the middle here and find a balance between the two. And to that end, I think we've been really pleased with what we've heard from Director Iancu. I think one of the key areas that he's spoken to, and I've been very glad to hear from him on this, is 101. In my opinion, 101 it's turned into a very difficult area of the law to deal with. It's an area of the law that never really used to be very difficult to deal with. A while ago, not long ago, a patent attorney sent around, he collected basically 11 claims that had been litigated or decided in some way, shape, or form under 101. He sent them around to a large collection of patent attorneys. And he just, almost like a multiple choice test, had them go through here and tell me whether this is valid or not valid. And I know me and some of my colleagues, we sat down and we diligently went through these and tried to do the very best that we could. And out of the group, the average was something like 4 out of 10 that we, ostensibly got right. The highest score was 6. And I think that, certainly he picked cases that would be somewhat controversial. But in my career up to that point, I couldn't imagine that only 40%, that a collection of patent attorneys as a whole could only get 40% of the question right on what's patentable. It's also disturbing from a legal standpoint because we have very well-ordered boxes that have developed over north of 100 years of jurisprudence that include 112, 103, and you see sort of the conflation of particular areas of law into a 101 analysis. This is something that 101 was never designed to deal with. Some of these things are also factual issues that are being handled at the 12B6 stage, which is the motion to dismiss stage. So, at 101, it has to be addressed. It's not workable as it is right now. I think the other areas that we look at, when we look at the PTAB process, certainly a lot of patent owners have been upset about it. From our perspective, I think the thing that I find somewhat disturbing about the process is not so much the notion that the PTAB can reevaluate a claim. It's that first of all, there's no standing requirement as to whether you can evaluate a claim or not. And there's also the possibility of settlement after you do try to institute a claim. So those two things in and of themselves just allow for all sorts of shenanigans. And I have attorneys that are afraid if they get a verdict in a case that they know coming out of the woodwork somebody's going to file an IPR against them, and then they're going to want essentially a small settlement. And so it allows for an area of gamesmanship that I don't think was really ever intended, and I think it's something that can be dealt with at the USPTO level. And so I think the notion that you can be subjected to repeated attack after attack after attack on a patent it really lends to a lot of uncertainty with respect to the property right. The property, you have to have a certainty and at least some certainty in a property right for it to be a legitimate investment vehicle. And so I think that area, this sort of the notion that I can be hit by anybody and I can be hit over and over again until eventually somebody gets a panel that doesn't like my patent, and then that's the end of it. So I think that part is a key thing that needs to be addressed. I think the third thing that we have concern of from an investment standpoint is that when you have an area of law that has had the amount of flux that patent law has had over the last decade, that in and of itself is problematic. And so I would like to see a period in which, once we work out some of the kinks of the PTAB process, 101 gets sorted out a little bit, I like to have a period in which there's not a lot of changes in the system. I mean, it becomes very hard to price things if the law changes every other year. So, or actually in a faster time scale than that. So I think those are really our three areas that we would focus most heavily on.
Great. Thank you, Mark. So now let's focus in a little more specifically, now that we've outlined some of these issues. How serious a problem is patent litigation abuse, number one? And number two, have the recent court decisions and AIA guidelines and other AIA regulations, other patent office guidelines, have they helped make things better? Is it enough to root out the problem? So Aaron, do you want to speak to that to start?
Sure. So first, we have BSA is our association is a combination of companies that are always on the top 10 list of patent grantees, and they're also on the top 10 list of companies that get sued for patent infringement. So we tend to see both aspects of this, and I think that misuse of the patent system continues to be a problem. It's not the problem that it was a decade ago, but it would be, I think, overly optimistic to think that any amount of legislative or regulatory or judicial changes is going to completely eliminate the problem. But I think that a lot of the changes that happened around the time of the AIA, both from the IPR process and several important court decisions since then as well, have definitely shifted the dynamics so that there is less misuse of the system from patent holders, I think, but there is a problem in being able to enforce legitimate patents. And I think what we should all be striving for is if you have a clearly novel invention that clearly defines the claims and the metes and bounds of the property right, that it should be easily enforceable. And on the converse, if you're trying to game the system, if you're trying to assert that your claim covers the entire internet when it didn't when it was filed, we should be able to weed those out of the system. And I think we should be constantly striving for that balance. I think some of the recent court decisions, especially around venue, have been helpful in cutting back on some of the gamesmanship around patent litigation. I think that there's room for improvement in the IPR system, and it's only been in effect in this form for a few years now. And so I think it makes sense that the director is looking at ways to improve it, and we should be constantly calibrating whether it is either overprotecting or underprotecting property rights.
Thanks. Mike, how about you?
I mean, I agree with what Aaron's saying. I think the amount of litigation that we might describe as somewhat trollish has gone down since AIA was enacted. Thank you, Aaron, for taking care of that. But it's still much higher than it was 20 years ago. And so our member companies spend a significant amount of time and money in investing in intellectual property, and they end up spending way too much money in courts litigating against overly broad or poorly written patents that have been granted. So we continue to, like Aaron says, a lot of the things that have happened in the last few years have been very helpful in curbing some of those problems, but we continue to seek for a good balance.
Great. Any of the other of you guys want to comment on that? I'll just note in general, here at AEI, we always try to encompass a wide range of views on different subjects, different industries, different sectors, different perspectives. I'm hearing a little too much agreement today.
Yeah.
So I think we need to kind of spice things up a little bit.
And I'm happy to jump in on this side of the issue. I think it's a mistake to talk about this issue as if it's a single-sided problem. I mean, the notion that sort of bad action is inhomogeneously distributed and only occurs on the patent side, I think, is a fallacy. I think that there's certainly bad behavior on the opposite side of the table. I mean, there are any number of things. People who actually need licenses and won't take them, they rely on sort of the inefficiencies of the system to devalue the value of licenses in the marketplace. I mean, that happens. It's a thing. It doesn't get any attention, but it certainly is the case. There's a few things I think are that I find entertaining about this end of the conversation, and that's one thing when I hear people complain about litigation costs, but then when I see their behavior in litigation, they're a prime reason why they're running the costs up. I mean, they're taking 20 depositions around the world and they're asking for every document, and they're bringing every motion, whether it should be brought or not. I think it's a mistake to think that bad behavior is a patent owner centric thing. I think it occurs across the spectrum, and I think it's something that people should have an eye out for.
Michael, I don't want to disappoint you, but I completely agree. I think it's important it is important to look at misuse of the system on both sides, and we should all be striving for what I think is the ideal system that enhances dynamic efficiency in the market by making sure that we do our best to cut down on misuse on either side, either misuse of a patent or a decision from an implementer side that I know that's a valid patent and I know it reads on what I'm doing, but I'm just not going to take a license anyway. And I think if we can make patents that are clearly valid, clearly defined, easier to enforce, and weed out those patents that really shouldn't have been granted in the first place, I think that's best for the system overall.
We're so balanced today. So I want to agree with that too. Just add one observation, because I often find in discussions on, well, is the PTAB working, or what do you think about the state of Section 101? Just to take two, that we struggle with the metrics that we apply to saying this works or it's not, or it's desirable or it isn't. All too often, people with whom I discuss appraise these systems from the perspective of, oh, but it wins cases, or it interferes with my business, right? So if it's good for my business, it's got to be good and desirable, period. And if it's not, then it's not. So that way you always ever end up with people who can't agree because they have to keep their own business in mind. Right? That doesn't mean, just because the PTAB kills a lot of patents that that's good or desirable. Or the same thing with Section 101, it wins cases or not. I think in a setting like this, which brings together academic thinking, with the needs of the business community, I think it's much better to appraise the system as a whole and ask, does it add value to the functioning, of society, of the economy, and is it a net positive? Right. So I really think it's important to get away from the posture of I need this because it wins cases for me.
Great. Well, and I think along those lines, let's talk for a minute about Patent Office trials and how that fits into that framework, or the framework we should be looking at things. The director has announced that the office has issued the sort of draft regulations on broadest reasonable interpretation and claim construction standards. So generally, how well do you think the Patent Office trials are working, and specifically, what are your thoughts on the latest coming out from the director? So, Mike, you want to start?
Yeah, I mean, I think, when we look back to the AIA, I had just joined the Senate Judiciary Committee when that process was being finalized, and so got to watch the tail end of it. But I think that, albeit for me to speak for Aaron in this regard, but I think really one of the intents of the bill was to restore some credibility and reliability to the patent system. And I think when you look at patent quality issues in the patent system, you're provided with difficult choices policy-wise, because as I mentioned earlier, we frankly just don't have enough patent examiners with enough time to do a 100% job of making sure that the patents being granted are perfect. And in order to accomplish that goal would cost a lot of money and a lot of investment, and Congress is not necessarily good at directing money and investment in the right places. And so the alternative to that was to create post-grant review processes that would catch what gets through. And I think that part of the intention was to create IPR and in order to allow special cases to go back and get a review. In my opinion, I think IPR and the numbers that PTO releases, which are great numbers for a government agency, we do have a lot of data from them, and I think that it shows that the number of patents that are taken to IPR is really very small. Something like 0.2% of active patents have gone to IPR, and I think that when you look at that small percentage of problematic patents that end up in IPR, many of them are the PTAB dismisses the case right off the bat because it doesn't present problems. And so then the number gets even smaller. And so we look at the kind of survivability rates of IPR, and in actuality, we're talking about a very small number of patents. And so while it's a small number of patents, they're patents that cause a lot of problems for our member companies. And so we've been eager to support IPR because we think that the numbers show that it's actually targeted and working.
Something tells me Mark might feel a little differently about that, but I'll let you speak for yourself.
Well, I think, as I said earlier, the thing we had the most concern with is the sort of the aggregated attack scenario, and it seems like, and it's somewhat surprising to me, but there's quite a bit of debate over what the numbers actually are and what the statistics actually show. I mean, it reminds me a little bit about that joke. Did you hear about the statistician who drowned in a lake? And so I said, no, what happened? And he's like, well, it was weird. The average depth of the water was only 2 feet. And so, I wonder about, the way in which some of these things are being counted. I would suspect that they're a little bit on the higher end, if only because if you look at the reaction in the marketplace, I mean, we have people selling patents to Indian tribes. I mean, I don't think that's because they think, they're getting a great shot at the PTAB process. That in the numbers I've seen are actually pretty high, especially if you get instituted. Now, I think that our director is moving towards solving some of those problems with the change in the standard for claim construction. And certainly if they move to, it sounds like they're moving to allowing amendments. I think, if you look at the way in which it was structured, I mean, in some sense, you could call it that, I don't want to use the word triad of evil, but I mean, there's three things that were really structured against patent owners: the change in the standard patentability. I mean, you have to prove an invalidity by preponderance of the evidence rather than clear and convincing. Then we're going to use the broadest reasonable interpretation of the claims, and even though ostensibly the rationale for allowing broadest reasonable is because you can do amendments, in actuality we're not going to allow amendments. So, I mean, if I have a combination of preponderance of the evidence, I've got broadest reasonable interpretation, and now I don't have the ability to amend. I mean, I think that is structurally stacked against patent owners, and I think it'd be difficult to argue otherwise. I've been very happy that Director Iancu has taken an obvious leadership position in this area. He's already working towards the amending process, and there's other things that changing the claim construction standard. So I think it'll be. I'd like to see what the numbers look like. Maybe a year after we've had that. I certainly think that the years 2012, 2014, 2015. I think it'd be difficult to argue that the PTAB wasn't sort of slanted against patent owners. But I mean, I haven't read your statistics in detail, so.
Anyone else want to jump in on this?
I said this earlier, I hear a lot about PTAB proceedings from our members that I could probably touch on many points. The one I want to pull out and just raise here is, I think, the need to have these proceedings early in the process of the patent's life. I think if this proceeding is meant to be a patent quality measure, it should be applied to the patent early in the life and not late in its life, as is the case today. And what we also, I think, should keep an eye on in the PTAB, amongst many other things, is the need for finality and to avoid repetitive litigation. Currently, I think there's a widespread sense, and one gets this even from patent attorneys when one gets them into the room, that these proceedings add cost to the system of commercial dispute resolution rather than take cost out of the system, right? They are an opportunity for a second litigation over the patent, in addition to what is possible in district court. And, while they are often discussed in terms of a patent quality measure that's as innocuous as the PTO, the agency that grants the patent, just taking a second look at the patent, I think that sounds fine. And on its face, it's unobjectionable. But what if it's a third look or a fourth look or a fifth look? There are examples where patents only went down after the 10th look, literally. But that's probably not what Congress had in mind, but that's what the rules seem to allow. And patent owners are a little bit like pigeons, right? They go and pick at their technology and their business, and then something happens and they all fly all over the place and they get really excited. So it takes one example like this in your industry where somebody loses a big product and gets a really raw deal, right? Everybody learns the lesson really, really fast, right? And then the concerns are brought to us and said, please make sure that this never happens again. So I think finality, I think, is a subject that we should often discuss.
Great.
So I think the PTAB process is generally working well, but it's definitely not working perfectly. And I think some of the problems that you identified are good ones and need to be addressed, and the director is doing it, and that's a good thing. I think we should. I think the idea that Hans puts out there about finality and making sure that there aren't multiple challenges to a patent is in an ideal world the way things should work. I think as a practical matter, it's not really possible for a number of different reasons. First, I don't think anybody's suggesting that if there's an infringement action in court, that the court shouldn't be, or the defendant in the case shouldn't be allowed to challenge the validity of the patent. So there's always going to be some uncertainty about the validity of the patent because each defendant is going to have the right to challenge that. I also think that where you might have a claim of a patent that when initially granted seemed to be directed towards one thing, but now the patent owner is asserting it and asserting that it applies much more broadly in other areas, then it's going to bring in companies that wouldn't have thought about challenging it in the first instance, but now that it's being asserted against them in an entirely different context, I think we want to give them the ability to do it. Some of those companies might not have even existed when the patent was first granted. But I agree in that in an ideal world, we'd want challengers to use the first window post-grant review process rather than wait for the inter-party process. I just think that it's not, unfortunately, practical in all cases. And one other thing I just want to highlight is we need to remember the context in which these IPRs were put in place. There was an inter-party re-examination process that existed before. The institution rate in those in those proceedings was something like 96%. And one of the reasons why the IPR as it exists today was created was because of a concern from patent owners that I think was legitimate, that the institution rate was way too high, the threshold for instituting was way too low, and at the end of the day, there was never a decision. I think there was maybe one or two IPRs, inter-party re-exams, that actually went to finality, but otherwise they were just being used as a delay tactic in court. And one thing that the current IPR process has been able to do is bring those down to a 12-month decision and require that if the patent is in litigation, that the challenge happen early in the litigation, not at the last minute.
Great. No, thank you. Let's shift gears for a minute, sort of, and talk about legislative patent reform and what you all see as the prospects for it, whether it's the Stronger Patents Act or the Innovation Act, neither of which seem to be moving all that fast right now, to be honest, especially in an election year. I'm just curious about what your thoughts are on the prospects of that. So maybe we'll start with you, Mike, who I guess most recently was actually in the world's greatest deliberative body.
And as we all know, passing legislation is difficult to begin with. And having been witness over my almost 7 years on the Hill to many attempts to tackle additional patent issues post-AIA, and seen those efforts fail after significant amounts of energy and time put into discussions, my guess is that nothing's going to pass anytime soon. As far as our personal, as Internet Association, we do have strong concerns with the legislative proposals that have been floated around at this point. But as you said, this is an election year, and we only have a few weeks left of time to discuss these things. But we look forward to next Congress, when I'm sure we'll be continuing to discuss all of these patent issues and legislation.
All right. Hans?
Well, the PTO does need, I think, a renewal of its fee-setting authority, right? Which seems like a very technical measure. But once we're on the topic of saying, okay, we will do actually a bill for the PTO, why shouldn't Congress put out calls for, is there anything really non-controversial, right, that maybe industry would want? Doesn't hurt to ask. It's not very likely that there's, or even if there is uncontroversial stuff that maybe one industry might want, other industries might want things too. But nonetheless, I don't think there's a lot of harm in asking whether anything should be added to that bill other than a renewal of fee-setting authority. If nothing gets added, at least we've had a friendly conversation and we were able to identify subjects that maybe aren't as controversial as people thought. So let's have a dialogue about it, at least.
Sure. Others?
I think from our perspective, we'd probably rather not see additional legislation. I think we've got we have a new director. Let's give him some time to work. He's only been on the job for a couple of months, but he clearly has an eye to what the major issues are. I'd rather see them let that process play out and then sort of see where we're at rather than get in there and maybe you end up with something that you didn't want or it has a lot of unintended consequences because, it seems to me that the game theory portion of legislation isn't particularly strong and doesn't seem to be a lot of thought in terms of the way in which each of these different changes could be exploited on an industry-wide level. And so I think now it may be a period of quiet. Let's let the director do his job and then see where we're at in a few years.
We could have a hearing. We could have a hearing on Section 101.
I think even if there's not enactment of legislation, I think that the conversations and the work that the Hill does to highlight issues that are concerned to them, either because it's personal concern to them or because they're hearing from industries and they want to flesh out those issues, are important. And I think a lot of the things that were in the Innovation Act, for instance, you see the courts handling. A lot of the things that are in the Stronger Act, I think you see the director moving towards. So it's, I think that the work that goes on the Hill on legislation, even when it doesn't change the United States Code, does have an impact on what the law is and how it's applied. And I think that's important from both sides.
Great. I want to make sure we have a little bit of time left still for Q&A, so we're going to move to speed round. So I'm going to give you some quick questions. Just if you can, one sentence answer, feel free to pass. Your answer can be authentic and real, or it can be frivolous and funny as well. So let's start with how well, in your opinion, has the Trump administration been handling patent issues? Hans.
I think they're hitting their stride. We heard it earlier. I have no reason to complain at this point.
Mike?
Yeah, I think the director's been doing a really good job of being thoughtful and reaching out to lots of different industry players to figure things out, and we're excited to continue working with them.
Yeah, I agree. I think one of the nice things about patent issues is that they are inherently not partisan, and I think each director comes in facing a different landscape in terms of the balance in the IP system. But I think the administration's been doing a good job. I think before the director, the acting director Mittal was doing a good job, and Director Lee before that. And I think that everybody just takes the patent system and makes changes based on what they're confronting.
All right.
Yeah, I'd agree with that. I think Director Iancu has shown great leadership right at the outset. He's clearly honed in on the core issues, and so far, so good.
All right. Thank you. Next question. The so-called tribal strategy, which Mark alluded to, of companies stashing their patents with universities or Indian tribes. What are your thoughts on that, and will it hold up when it gets further up through the courts as a strategy or in Congress? We'll start with you, Mark.
It's something I hate to see, and I think if we see a little bit more balance brought to the PTAB process, those sorts of things wouldn't be a strategy. I don't think it's a good strategy. It just sort of undermines the credibility of the system.
Aaron?
From Mark, I like that point. That you don't want gamesmanship on any side of patent issues.
Mike?
Yeah, I mean, I think it was a creative strategy, and I think they thought it was worth a shot, but I don't think it'll last.
Hans?
I think it's a symptom of something that's wrong. I don't think in itself it is a problem. What worries me about the dialogue we're having around that, and wherever it might go in the courts, is that IPR and the ability to use the PTAB is going to be played up as something that's so important that it overrides other pretty darn important things, including deep constitutional questions of tribal sovereignty, the status of universities as agents of sovereign entities. Right? So that is pretty important too. Right? And I'm not sure the ability to use the PTAB per se should be equally important or of the kind that should override these questions. I don't think this will be over anytime soon. I think the appeal that's going through the Federal Circuit is one of the more interesting cases to watch. And I don't think it will be over at the Federal Circuit, whatever they decide.
All right. Final level. We're up to going after the main big boss. This is kind of an unfair question. I'm going to ask it anyway. In one sentence, what would you do to fix 101, or do you not need to fix 101? Mike?
I think that there can be continued guidance from PTO, but our companies continue to be able to secure patents that are technical solutions to technical problems, and we think that that's a standard that we should uphold.
Aaron?
There's not a one-sentence answer.
That's actually paradoxical. Think about that for a moment. All right.
I'm going to go with the one-sentence answer. Everything under the sun made by man. I think that was the best formulation of 101, and we deal with all the rest of the problems with 112, 103. It's a broad filter.
All right. Hans?
I say get rid of the judicial exceptions. And Director Iancu was right on that point too. If we decide as a society that there are certain things that we just don't want to be available for patenting, maybe we should take a look at what other countries and jurisdictions have done. A lot of systems actually have made that decision, and they said, we don't want patents on whatever, fetal cells or human beings, whatever it might be. Well, and they just sat down in a legislature and said so. But I think at the end, at least that's going to be more manageable and democratic than applying judicial exceptions whose doctrinal origin is really ultimately unexplained. Right? I dare anyone to tell me where this law came from, and what doctrinal origins it has. Other than that, a Supreme Court justice in the 19th century just said so one day.
Thank you. Great. You all passed. Excellent. We'll turn now and save some room for questions. So you, sir, wanted to ask one before. We'll start with you. And again, please identify yourself and speak into the microphone.
Mark Brodsky, retired CEO, physicist, engineer, inventor. I'm going to ask a philosophical question. When we think of patents in the general public, and we're not educated on the patent system, and what I think the Constitution envisioned, the patent, the invention, was the product. Today, many of the patents, not all, drug companies, drugs being a big exception, the patent is an ingredient in a bigger, an ingredient among maybe hundreds or thousands in a product. And should we think differently about a patent that is just part of something rather than being the whole something?
I think no. I think that we have complex products and services, and that how we value each one and how we determine what an appropriate license fee is in the marketplace, or what damages and a reasonable royalty are, differ depending on the answer to that question. But in terms of how we think about the importance of protecting new and useful inventions, I think we should think about it the same way.
Anybody else? All right. Sir?
Bert Ely, a banking consultant. In my answer to, or my question to the director with regard to business method patents, my sense was, and I may have misinterpreted what he said, that he seemed to express a little bit of skepticism about business method inventions as something that should be patentable. What are your thoughts about that in terms of how to interpret what the director said, and what your own thoughts are about the patentability of business methods?
I think that what the director said about depends on what we mean by a business method is an important one. But as a general matter, I think Alice said that methods of doing business are not patentable, and I think as long as we restrict it to methods of doing business, at least from our membership, we're generally comfortable with that. But it's hard to draw that line.
I believe that the problem many people have with business method patents when they see one, and it's truly a method of doing business that governs human interaction or transactions, is the patent is seen, the invention is explained, and people say, I don't understand why that's patentable. That's blatantly obvious. People have been doing this forever. So in other words, I think what the director was saying, if it's really a new idea, right, not the one that's captured by the reaction I described. If it's truly a new idea, truly novel, truly properly described, the kind of thing where people would say, nobody ever thought of this. That is a really great idea. maybe our attitude towards business method patents would change, right? Even assuming that we consider them worthy of patenting. And the alternative, I think the director was right. We could say, even if they're really good ideas, we can decide, sit down together, and decide we don't want these things to be available for patenting, no matter how new and awe-inspiring they are, and how creative. And that, I think, is Congress's prerogative to do. It has never done so. The only people who've done so are judges and other unelected folk, right, who have created these doctrines.
So then, using the director's metaphor, the question is, does the run and shoot that Houston created in the 1980s get patent protection?
Great question. Spread offense.
Ultimately not useful.
Right.
And with respect to the sports move, just real quick, I had this actually explained to me by a Japanese colleague who said, oh, in Japan, says we play a lot of baseball too. He said, and so I asked him, well, what about a method of throwing a curveball? This was something that Judge Rader also sometimes used. And he said, oh, in Japan we think of this, now I hope I repeat this correctly, as something that's not really capable of patent examination to begin with, because it's not really capable of a true technical description. He says this is more like an art that you have to practice. And even a master can't explain to his student in words exactly what to do, to throw the curveball. So how would you reduce it to a written instrument that's capable of patent examination? He says that's why we say these things aren't patentable, because they're not capable of being reduced to writing and capable of being examined.
Let alone a knuckleball, right? That's even more wonderful. Yes, one last question in the back, ma'am.
Hi. I've been working with Italian inventors for some time now, most of whom do not patent, and there's nothing I can do to convince them to do so. They are convinced. Only one has a patent pending here in the States that I've been working with. They're convinced that the Chinese will steal their idea as soon as it gets into the process. The fact that investors want patent protection and that having a patent will help with them, some legal remedies cannot convince them. Do you see any possibility, any future tools that could be used either on the legal side or the patent side to address this issue?
Not in the short term. I think my answer to that would be, that's why it's so important that industrialized countries and those who want to join the ranks of industrialized countries where inventions are not just produced but also made, I think join in discussions over harmonization, where we join in the WTO in an agreement to respect each other's patents, to harmonize each other's standards of patentability, so that the kinds of things that are patentable in Japan are the same kinds of things that ought to be patentable in China or the US or somewhere else, and that we respect patents that are filed in our country, even if they are inventions that were invented elsewhere and by foreign inventors. The system only works on a principle of reciprocity, and it breaks down so quickly when countries pull out and say the system doesn't do much for me, I'm going to stop respecting other people's intellectual property. We see this like in many manifestations in the life sciences and drug space in particular, where drug patents are under a lot of pressure in many countries. So there really is no substitute to a long-term commitment, I think, to a rule of law, trade agreements, and reciprocal respect for intellectual property.
Well, on that note, I'd like to thank you all for your very insightful and thoughtful contributions to the conversation, and I hope we continue to engage in these issues over the coming months and years. And thank you all for coming and participating as well.